The Nigeria Union of Petroleum and Natural Gas Workers has accused the Dangote Petroleum Refinery of sponsoring division within its petroleum tanker drivers branch. NUPENG accused Dangote of resisting workers' rights to unionization and deploying what it described as falsehoods to undermine the union. NUPENG also accused the company of using a Greek gift of free nationwide petroleum delivery to undermine the union and stifle competition. In a statement signed by its National Executive President, Williams Akporeha, and the General Secretary, Afolabi Olawale, the union on Friday dismissed a press release by the Dangote Group. The Dangote Petroleum Refinery had on Thursday dismissed recent allegations by the NUPENG that it banned tanker drivers from joining the union. We're now joined by Todimu Ige, a lawyer, for some insight on this story. Mr. Todimu, thank you for joining us. Good afternoon. Can you tell us, is it possible that a company in Nigeria can legally stop or discourage its workers from joining a union like NUPENG?
Well, the provisions of Section 40 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, states that Nigerians have a right of association. Having said that, what that means is that Nigerian workers have a right to join lawful associations. So to answer your question, simply, Sita, it will be unlawful for any organization, company, or body to stop workers from joining lawful organizations or society.
Okay, so Mr. Todimu, what can NUPENG do legally if Dangote refuses to follow the agreement? That's the memorandum that was signed on September 9th.
Now, when parties, aside from the provisions of the Constitution, which empowers them to approach the court, now, particularly the workers who have been disenfranchised, who have been told not to join any union, they can actually approach the court to enforce their rights as protected and provided by the Constitution of the Federal Republic of Nigeria. Number two, what the union can also do is to approach the court, because if there's a memorandum of understanding is enforceable and legally binding on parties, and either of the parties who have this understanding can approach the court of law to ensure that this is enforced.
So you mentioned them, going to court, but so this memorandum of understanding, is it binding in court? And what happens if the company breaks it?
Yes, the memorandum of understanding, ordinarily when parties have a memorandum of understanding is a document that states the facts and understanding between parties. And now, when such a document is being drafted, lawyers are a way of stating that this memorandum of understanding is legally binding. And now when parties, what that means is that it becomes a contract between the parties. If there is a breach, then either of the parties has a right to approach the court for interpretation and enforcement of that agreement.
And then they also mentioned that, Dangote is backing another drivers group to replace NUPENG. Does that break workers' constitutional right to join unions?
Well, if they are alleging that he's backing another another group, what he's saying is that what this means is that the law is clear that you cannot stop the workers from belonging to a lawful association or society. Now, if there is competition, and he's saying that I'm backing this competition, so far his workers are not compelled to be part of any other society. What it must be freely done, they must not do it under duress. That's the provision of the law. So the workers also have a right to approach the court and say, no, we are being compelled. And of course, if they are compelled, it is against the provisions of the Labor Act. And of course, the workers can back out of it and it's not binding on them. They can approach the court for proper interpretation and enforcement of their rights.
So, Mr. Todimu, tell us, as a lawyer, can the law balance a company's right to run its business the way it wants with workers' right to unionize?
Well, the activities of the union, of course, if it is the activities of the union, the essence of it is to protect the workers. Now, it doesn't now mean that they can also now begin to force the company to do what it doesn't want to do. Yes, they can serve as a pressure point, but they cannot mandate the company to act in its way. The company also has the right to approach the court to say, the activities of the union is impeding our organization and our operation. They are putting us in a position that would make us break the law, that would not make us act effectively as a company. So, any of the parties can actually approach the court to say the activities of the union is impeding me. Of course, the union can also say the activity of the company is impeding the union. So either of the parties have a right to approach the court to ensure that they are not put at a disadvantage.
Well, thank you so much, Todimu Ige, for joining us and giving us an insight about the Dangote and the NUPENG issue. Thank you.
Thank you for having me.